that are being in operation in different countries or even in the international world. So whenever there is a non-disclosure of material fact, it may affect, the parties. Okay, it may affect the parties. So sometimes a feature of this duty that we are talking about, that we say must be of full and frank disclosure. If this particular duty is breached, the affected party would have to exercise a certain right to avoid himself from actually paying compensation if they realize that you have not disclosed certain truths. Okay. So, but of course, you need to understand what will constitute a material fact. Okay. You must understand what constitutes a material fact. So whenever you are procuring an insurance, you would be asked certain questions. Suddenly they ask you about the history of claim or history of your losses when you are filling the insurance policy. They ask you questions relating to the value of the cargo, whether there's an overstatement or undervaluation, if that exists. They ask you of cancellation of any previous policies and the reason for such cancellation or any special terms that might be has been imposed by previous insurer. They may also be asking you about the existence of any other insurance policy covering the same risk. Okay, somebody may decide to insure certain risks twice, and this is a material fact, and it must be disclosed. So there are others, but there are certain exemptions. Even though they are also important things, they may decide not to actually let you disclose them, and it will not be able to affect the policy. So these are some of the exemptions when it comes to material fact. So we say that the following types of facts are not required to be disclosed by the proposer. That is, the non-disclosure of them shall not be fatal to the contract. For instance, any fact which minimize the risk, okay? Any fact which is also known or presumed to be known by the insurer already, or any fact which is of the nature of public knowledge, which relate to the law of the country, or any fact that to which the information is waived by the insurer. Sometimes the insurer themselves will waive certain information. They may not be interested in it. So those ones are exempted. But there are consequences for breaching. So if the utmost good faith is not observed by either party, the contract will become voidable at the option of party not at fault, irrespective of whether the non-disclosure was intentional or not. So this is very, very important. There must be a full and frank disclosure of material facts on the part of both parties. Another principle is the principle of indemnity. A contract of marine insurance is a contract of indemnity. This must actually be placed at the back of our mind. The contract of marine insurance is a contract of indemnity, except of those of life and personal accident insurance. So indemnity does not apply, okay? Principle of indemnity does not actually apply to life insurance, okay? Where no amount of money can be used to indemnify the loss of one's life or bodily injury. In the case of marine and fire insurances, the insurer undertakes to indemnify the insured for loss or damage resulting from specified perils. In case of loss, the insured can be recovered from the insurer the actual amount. So underline this word, the actual amount, not exceeding the amount of the policy. Let me state here that we do not procure insurance to benefit or to make profit. We don't do that. We don't procure insurance to make profit. Let me pause. So, in effect, if there is no loss under the policy, the insurer is under no obligation to indemnify the insured, of course. The object of indemnity is to place the insured after a loss in the same position as he occupied immediately before the event. So it is not to make you a better person, or it's not to indemnify you more than, what you have lost. The object of indemnity is to place the insured after a loss in its original position. Okay, that's what it means. So under no circumstance is the insured allowed to benefit more than the loss he or she has suffered. So this is the principle of what? Indemnity, and it's applicable to marine insurance. You don't benefit more than the loss you've suffered. So we always ensure that this particular policy or this particular principle has been adhered to. Another principle is the insurable interest. Insurable interest here is an essential prerequisite in effecting a contract of insurance. The insured must possess an insurable interest in the subject matter of the insurance at the time of contract. Otherwise, the contract of insurance will be wagering agreement, which shall be void and unenforceable. So these questions, this even answers the assignment that was given about, whether an insurance contract is the same as wagering agreement. So with an insurance, there must be an object, there must be an insurable interest. Okay, there must be an insurable interest. Indemnity in the contract law, indemnity is a contractual obligation of one party to indemnify or to compensate the loss incurred to the other party or the indemnity holder, except those of life and personal accidents where no amount of money can be indemnified for loss of life or bodily injury. In case of marine and fire insurance, the insurer undertakes to indemnify the insured for loss or damage resulting from a specific or specified perils. This has already been mentioned in the previous slide. The other cause or other fundamental principle of insurance contract is causa proxima, or proximate cause. Okay, this one talks about the next principle, which states that the insurer is liable only for those losses which have been approximately caused by the insured, by the peril which has been insured. Okay, so in insurance we have some types of perils. We have three types of perils. We have an insured peril. Okay, that's the peril in which that particular object or property has been insured against. Okay, and then these are intended to be covered. Okay, these particular perils are intended to be covered under the insurance policy. For example, somebody may decide to insure against fire, may decide to insure against damage caused by poor handling. Somebody might decide to insure against maybe flood or something, or theft. Okay, so that is called a peril, and include an insured peril. So, or we call it an included peril, if you wish. And we also have something called uninsured peril. Uninsured peril talks about those that do not cover, okay, that are not covered yet, not expressly excluded, okay? Even though they are not covered, they are not explicitly excluded under the policy. For example, a natural phenomena such as climate change or somebody would say an act of war, okay, an act of God, okay, an act of God or out of natural circumstance. All those things, okay, even though they have not been insured against, but they are not explicitly what excluded from the insurance policy. So they may lead to what? A compensation. And then the last one is what? Excluded perils. These are those that are expressly what? Excluded from the coverage by the policy by a specific clause or provision, either because of an inherent vice of the cargo or obviously improper or inadequate packing.